There is a famous Tirukural, that is 424th Tirukural, which says, "En பொருள்வாகச் செயச் சொல்லி தான் பிறர்வாய் நுண்பொருள் காண்பதறிவு." This is a Kural about Arivudamai. This is a fittest Tirukural for a resource person wherever he is parked. Thiruvalluvar says, தான் சொல்லுவன எளிய பொருள் உடையாக பதியுமாறு சொல்லி, தான் சொல்லுவன எளிய பொருள் உடையவனாக பதியுமாறு சொல்லி, தான் பிறரிடம் கேட்பவற்றின் நுட்பமான பொருளையும் ஆராய்ந்து காண்பது அறிவாகும். What a foresightful couplet by Saint Thiruvalluvar. So a good resource person is a person who not only delivers lecture out of his own acquisition of ideas from others, he should learn by observing and acquisition of knowledge from others. This is a hallmark of a resource person. I am still trying to be a good resource person. I only leave to the audience and judges to decide whether I am not or so. Today's subject, law of easement, is the one which we use frequently in our life. But we don't apply in the courts because after the urbanization, easement has become a subject matter of rural areas. But come later, after 2000 or something, when the culture of multi-story building and apartments started coming in all over the state, irrespective of a rural or urban area, easement has become more relevant after the advent of these multi-storied apartments, because there is an easement called easement of lateral support and support, light and air, everything is there. So this subject is something very important for us to know, both as an advocate as well as judges before the subordinate judiciary. Even now, in the rural areas, right of pathway, right of drawing water from a well, or right of passage to draw water from a well, right of water stream, right of undercurrent and underground water, everything is a subject matter of law of easement only. To cover or to have an overview of law of easement completely and thoroughly may not be an easy job. It may require at least 3 to 4 hours. So I'll confine myself to an introduction about what is called easement, how to acquire easement, and different kinds of easement. More importantly, easement by prescription. This is where the law is more little bit cumbersome. So if at all we want to know what is meant by easement, let us go to the origin of the word easement from Latin. It is from easmentum. Easmentum in Latin means a privilege or a convenience or a comfort. So if you define an easement, it is the legal right to either occupy the land owned by another person or use the facilities on land of another person for a specific purpose. That's very important. For a specific purpose, while the legal owner retains the title of the property. So easement is somewhat akin or closer to adverse possession, but the important distinction is it is for a specific purpose and there is no transfer of ownership. It is contradistinctive with adverse possession and lease, where the interest over the property is created. So once again, I repeat, an easement is the legal right to either occupy the land owned by another person or use the facilities on the land of another person for a specific purpose while the legal owner retains the title of the property. In easement, even after the prescription of the 20 years plus 2 years, the title never passes the hands of the real owner. It is still retained by the real owner. So even if the title is transferred, the subsequent owners are permitted to let the owner of the easement to continue the use of the land. If in the bilingual language, ஒருவேளை ஒரு சொத்தின் உரிமையாளர் தன்னுடைய சொத்தை விற்பாரேயானால் அல்லது அதில் ஏதாவது வில்லங்கம் செய்வாரேயானால், அவரிடமிருந்து வாங்கிய சொத்தின் உரிமையாளருக்கும் அந்த வசதி உரிமையை அனுபவிக்கிறவருக்கு கொடுக்க கடமைப்பட்டவர். This is what I can say in Tamil. So even if the title is transferred, the subsequent owners are permitted to let the owner of this easement to continue the use of the land. So for the purpose of acquisition of easement, 2 important tenements are essential: dominant tenement and servient tenement. Normally, dominant means person who has a title, but in law of easement, dominant tenement is the person who enjoys the right of easement. யார் அந்த வசதி உரிமையை அனுபவிக்கிறார்களோ அவர்களுக்கு பேர் தான் டாமினன்ட் ஈஸ்மெண்ட். யாருடைய சொத்தில் அந்த வசதி உரிமை தரப்படுகிறதோ அவங்க பேரு சர்வியன்ட் டெனமெண்ட். ஸோ டாமினன்ட் டெனமெண்ட் அண்ட் சர்வியன்ட் டெனமெண்ட்ஸ் ஆர் தி டூ prerequisites of a right of easement. They should vest with two different persons. That is very important. An easement may be acquired by the owner of the immovable property for the beneficial enjoyment of which the right is created, or on this behalf by any person in possession of the same. This definition may be kindly looked into. An easement may be acquired by the owner of the immovable property for the beneficial enjoyment of which the right is created, or on his behalf by any person in possession of the same. Now, let us decipher the definition into minutest details. Easement provides for a privilege, not only for the elite group of the society. It provides a privilege to the common people or any other entity to trespass upon or to take a land which is owned by some other person into use. தனக்கு பாத்தியம் இல்லாத, தனக்கு சொந்தம் இல்லாத, பிறிதொரு மனிதருக்கு பாத்தியமான சொந்தமான இடத்தில் புகுந்து அதில் உள்ள ஒரு உரிமையை அனுபவிக்கும் வசதியை கொடுப்பதுதான் வசதி உரிமை. No one can acquire a prescriptive right to commit nuisance or another man's land. Normally, when academicians faces the crowd or the law school teachers faces the student, the first and foremost doubt a student raises is this: whether an act of nuisance amounts to acquisition of right of easement. The answer is a big no in the negative. There is no right, even by prescription, to commit nuisance on another man's land. For example, I would rather say that there is a lot of distinction between walking across another man's land and throwing a filth on it. There is a distinction between a right of walking across another man's land and the right to throw filth on it. While the former is an act of trespass, that is, walking across the other man's land is an act of trespass. If committed without the consent of other, the later becomes a nuisance. This is the important distinction between nuisance and the easement. So, a right of way, pathway, may also be acquired by prescription. This is what is the important part of this session. We are going to deal mainly on the acquisition of easement by prescription. A right of way, pathway, may be acquired by prescription if it is exercised openly and with the knowledge of the owner of the servient tenement. ஏற்கனவே பார்த்தோம் servient tenement அப்படின்னா is the real owner of the property. So ஒரு வசதி உரிமையை நாம் பிரிஸ்கிரைப் பண்ணி அதனுடைய உரிமையாளராக மாற வேண்டும் என்றால் அந்த வசதி உரிமையை நாம் அந்த சொத்தினுடைய உண்மையான உரிமையாளருக்கு தெரிந்தே அவர்களுக்கு தெரிந்தே ஒரு குறிப்பிட்ட காலத்திற்கு அனுமதித்திருக்க வேண்டும். This is what is called a prescriptive right. But a right to commit nuisance cannot be acquired by prescription, no matter how often the act of nuisance is repeated. There is no right by way of necessity to commit nuisance on another man's land. So, when the Eastment Act came into India, it was as early as in the year 1882. Originally, it was an ancient law. In around 15th century, it emerged as a legal right, and Britishers brought it to India in the year 1882. The act is very few enactment, which is less amended or not even touched by Indian parliamentarians. The act puts easement in the list of rights provided to the people and states, that an easement is that right. This is the definition of Indian definition of easement. Easement is that right whereby the land is possessed by the owner or some other occupier of the land for the beneficial use in a way that allows him to perform or prohibit and continue to perform or continue to prohibit something. The next word is very important, or next sentence. Something that is being done on certain pieces of land that is not owned by him. So ஒரு மனிதன் வசதி உரிமை கோர வேண்டும் என்றால் தன்னுடைய சொந்த சொத்தின் மீது அவன் வசதி உரிமை கோர முடியாது. அல்லது ஒரு சொத்தின் மீது பாத்தியம் கொண்டாடினால் அந்த சொத்தின் மீது வசதி உரிமை கோர முடியாது. This is a very important point of law of easement. Merely by giving the easement right for some particular reason, it does not imply that the person with such easement can use the land according to his own whims and fancies. And once again I repeat, the ownership of the land is not passed along with the easement. Rights of the owner of the property still remains with the same person only. So when an interest arising from a non-possessory property is granted to easement holder, when an interest arising from a non-possessory land is granted to the easement holder so that he can use the land possessed by some other person is known as an easement. So once again I say, easement is a right that enables a person to use a property even when he is not the owner of the property. Such a right is granted by the owner of the property for the purpose of enjoyment of some rights for water, light, ingress and egress, etc. So easement is only a limited right where there is no transfer of ownership. Only a right is created over the property of another man's land. So now the important point which we are supposed to go through is the definition of the word easement as per section 4 of the Eastment Act. I am going to deal only with 7 or 8 sections of the Act. Section 4 of the Eastment Act defines what is called easement. It's the original English legislature, so there is no room for any confusion or ambiguity. The right to use easement over a period of land may be passed on to the beneficiary by means of law through continuous use of the land over and above a statutory period of time by grant or by prescription. So normally an easement is acquired mainly, not absolutely, mainly either by a grant or by prescription. What is meant by acquisition of easement by grant and what is meant by acquisition of easement by prescription? There is a distinction. If a right of easement is created or conveyed through a document, it is called a easement by grant. So the right is granted through a conveyance or through a document or through an instrument. That is called easement by grant. Easement by prescription is like adverse possession. One person uses the property of the real owner only for the purpose of enjoyment of some limited right, like right to graze cattle, right of light, right of air, right of support, a right of passage, a right of draining water over eaves. Such things are other easement, and certain easements can be prescribed by possessing the right for more than 20 years and filing a suit within 22 years. 20 plus 2 years, I'll come to it a little bit later. So prescriptive easement is a right over another man's land acquired by continuously, openly, peaceably enjoying the right for more than 20 continuous years without any interruption, and that is called easement by prescription. So easement by grant is a grant of the easement right by a document, and easement by prescription is by prescribing right of easement over another man's land by a flux of time of 20 years. This is the important distinction between prescription and the grant. For a better judgment on this easement by prescription, I have one case law called Jabamani versus Mani Chettiar, 2002, volume 2, MLJ, page 743. Jabamani versus K. Mani Chettiar, 2002, volume 2, MLJ, page 743, where the Madras High Court has given the complete and minute details of what is an easement by prescription. So I got one more case law because we have seen a lot of plaints by what is called following the new CPC. The new CPC is not Code of Civil Procedure. The new CPC is copy and paste code. When some other types of plaint, when you go for a similar plaint, we cut, copy and paste. That is how we have got a lot of pleadings where a declaration of title is pleaded on the basis of document of title and also in the alternative on the plea of adverse possession. We pretty well know very well that a plea of declaration of title through a document cannot get along with a plea of adverse possession. They are mutually destructive and they are inconsistent. We all know only a defendant can take inconsistent plea. Even a defendant cannot take mutually destructive inconsistent plea. But in suits for title, if you claim title through document, you are not supposed to claim title through adverse possession. Similarly, when you claim a right of passage or right by any document, you cannot claim easement as an alternative or another source of title. This is given by the Madras High Court in a case law of the same year, 2002, volume 3 MLJ, page 803. Vedavalli Ammal versus Kathai Ammal. 2002 3 MLJ 803 Vedavalli Ammal versus Kathai Ammal, which says whether declaration of title and recovery of possession can be claimed in addition to easement. The Madras High Court said no. Then, for a better appreciation of what is called easement, we got one classic judgment of Madras High Court of the year 1916. None of us would have been born at the time. Year 1916, Madras, page 1001. Muthu Gounder versus Ananda Gounder, where the Madras High Court has gone to the fullest detail of the elements and ingredients of a right of easement. It says Indian Easement Act is a remedial one. It is neither prohibitory nor exhaustive. A man may acquire a title under it who has no other right at all, but it does not exclude or interfere with others' title, and it prescribes mode of acquiring easement. AR 1916 Madras 1001 Muthu Gounder versus Ananda Gounder. Then, for certain rights which is attached to the property, the word used in easement is a French word. It's called profit et prendre. Profit et prendre, Profit space A space PRENDRE. Profit et prendre is a right attached to a particular property. For example, I have a right to take a tree or soil attached to earth. That is a profit et prendre. Or I have to catch and carry away fish attached to a water course. The right of fishing is called a profit et prendre. There is a judgment of Madras High Court, again in the year 1924, a classic judgment. AR 1924 Madras 108, Ganguly versus Jagannathan. AR 1924 Madras 108, Ganguly versus Jagannathan, where the Madras High Court has given the finest meaning and interpretation of the right of grant of profit et prendre. The grant of profit et prendre has to be by means of a registered instrument only. Profit et prendre cannot be prescribed. It can be only by an instrument. So it is a right that can be derived only by a registered instrument. Accordingly, the transaction of sale of the right to catch and carry away the fish, if not effected by a registered means of document, it won't pass the title. This is what is the Madras High Court held in AR 1924 Madras 108, Ganguly versus Jagannathan. Then there is one more right. I just give the judgments for the better appreciation of the ingredients little bit later. Flowing water from an artificial water course is an apparent and continuous easement, and there is a judgment of Madras High Court of the year 1966, AR 1966 Madras 158, V.R.V. Chettiar versus M.K. Ammal. V.R.V. Chettiar versus M.K. Ammal, AR 1966 Madras 158, where the Madras High Court has held that flowing water from an artificial water course is an apparent and continuous right of easement. If the rights were given for the purpose of repair periodically, it was held that such a right to access is for a particular purpose and for a particular period only. Then, if you want to understand the distinction between easement by prescription and easement by grant, there is a judgment of Madras High Court in the year 1972, AIR 1972 Madras 307, K. Govindarajulu versus VNS Naidu. AR 1972 Madras 307, K. Govindarajulu versus VNS Naidu. Here the Madras High Court is held as follows. The easement by grant is a form of alienation as Its effect is to take away a bundle of rights of ownership and transfer them to the occupier of the dominant tenement. So here the court has explained what is called an easement by grant. For better appreciation, please go to the judgment leisurely. Then we have come across this question might have come in our examination quite often. What is called easement by a doctrine of last grant? We know what is an easement by grant. What is called easement by last grant? So if I give the definition in a simple term, if it read as follows: if a party has been using a particular land for a particular purpose, if a party has been using a particular land for a particular purpose from time immemorial, that's very important. This is the sine qua non of a doctrine of easement by last grant. If a party has been using a particular land for a particular purpose from time immemorial, it can be said that he has earned that right on the basis of doctrine of last grant. Okay, now let me just move on to the center stage of this session, easement by prescription. Before going to the explanatory notes on the section 13, let me just go for one judgment of Madras High Court in the year 1987 that may give you a better idea of what is called easement by prescription. The verdict of Madras High Court in AR 1987, page 102, between E. Elumalai Chetty versus Naina Mudali and others. E. Elumalai Chetty versus Naina Mudali and others. The Madras High Court has ruled as follows: to acquire easement by prescription. To acquire easement by prescription, the user during the statutory period, that is 20 years according to the Indian Limitation Act. To acquire easement by prescription, the user during the statutory period should have been with the animus of enjoying the easement. So the animus is very important. Intention to enjoy the easement is the condition precedent to claim the easement right by prescription. I repeat once again, to acquire easement by prescription, the user during the statutory period should have been with the animus of enjoying the easement as such in the land of another person, and there must be consciousness and acceptance that the title in the land vests with the others, and the plaintiff cannot assert title in the land in himself. So, to claim the right of easement, to acquire the right of easement by prescription, we have got three important ingredients to be proved. Number one, we should have been enjoyed for the statutory period of limitation, say 20 years. Number two, we should have been enjoyed with an animus of using the easement right, and it must be in the land of another person, and the plaintiff who claims easement should not assert title in the land of a third party. This is what is called the definition of easement or prescription, or the ingredient by the Madras High Court. Now, we have got a similar right to that of easement in the Transfer of Property Act and any other common law or any other enactment. They are almost identical, but they are also not one and the same. I would just like to buttress upon some of the distinction of easement from various other concepts of law. As I said already, the easement is a right that enables a person to use the property even when he is not the owner of the property. The owner of the easement right is in a situation where certain rights are conferred on him, but not a right to possession exclusively. So the first important ingredient of easement is there is no transfer of possession of the property. There is no transfer of interest in the property by transferring the right of easement. The common law and many other jurisdiction towards easement per se is different in the sense that there is no transfer of property, there is no transfer of possession, there is no transfer of interest in the property while the easement is enjoyed. So, for example, when you go to the lease, lease is one of the transfer of property we all know. Lease is granted for a specific period or for perpetuity, 99 years, and creates an interest over the immovable property. In case of lease, the property and the possession is handed over to the lessee, and the possession is ingredient of a lease. And very important is the physical possession is handed over, it passes along with the lease deed. But whereas in case of easement, possession or the right or interest over the property does not pass the hands. This is between easement and lease. When you go to license, we have to see the distinction between license and lease first. Even in license, there is no transfer of ownership or possession. For example, parking slot. We go to a cinema theater or we go to an auditorium. We go to a concert hall or we go to a touring talkies. Touring talkies na பாதி பேருக்கு என்னன்னே தெரியாது இப்போ. Where we park the vehicle only for a particular time. So the parking slot, we have a right to keep the vehicle parked for a particular purpose for a particular time only. Thereafter, our life ceases. When the cinema theater is closed, you have got every right to see that your vehicle is out. That is not the case with the lease. So even in license, there is no transfer of ownership or there is no creation of interest in the property. But license is different from easement because easement is attached to property, whereas license is not necessarily attached to the property. That is a very important thing. Then distinction between this easement and license has been gone into, but we have to think one more thing. There is a case law in 1880 ILR 1880 Indian Law Reports, Volume 5, Calcutta, page 945. 1880 ILR 5, Calcutta, 945. Chandi Chand Rai versus Shiv Sundar Mundal. In this case, it deals with profit prendre. The Calcutta High Court was classic in its own way, stating that a profit prendre implies the right to remove and take into use any fragment of the soil that belongs to some other person and some other thing that is attached to the soil or that is lying on the soil with an objective of gaining the profits arising from the soil with the right to take trees, stone, gravel, and so on and so forth. For example, I have a right to pluck trees in the coconut tree of another man's land. This is a profit prendre. I have the right to catch and carry the fish in the stream of another man's land. It is a profit prendre. So this is different from a license, for which judgment is Chandi Chand Rai versus Shiv Chandar Mundal, 1885 ILR, Calcutta, page 945. Now, let us now go to an important thing of, finally, at the conclusive part of the definition part of the ingredient, what are all the essential ingredient of a valid easement? So I will say ABC. For an easement to be valid in the eyes of law, it has to fulfill certain conditions. Number one, it should get imposed upon some corporeal or immovable property. So the right of easement is imposed upon some corporeal property. Number two, it is a right to the land per se, but merely to use and enjoy the land. I repeat once again, it is a right to use the land, no doubt, but it is a mere right to use and enjoy the land, not to have a right of possession over the property. And thirdly, it should be comprised of the two other features, namely, first, the dominant tenement, by virtue of which the right is enjoyed, and the servient tenement, by virtue of which it submits to the tenement. So, number one, it should be imposed upon some corporeal property. Number two, it is a right to land per se, that's all, but merely to use and enjoy the land, no interest is created, and it should be comprised of two other features, dominant tenement and servient tenement. Now, we have to go for an important judgment of Kerala High Court, which has given a beautiful definition of a right of easement. AR 1988 Kerala, page 298. AR 1988 Kerala, page 298. C. Mohammed versus Anantachari. C. Mohammed versus Anantachari, where the Kerala High Court has given the following ingredients for a valid requirement of an easement. A. Creation of beneficial enjoyment of the dominant servient by easement. B. Entitlement of the dominant owner to perform and continue to perform, or to prohibit or to continue to prohibit something relating to the servient tenement by virtue of the easement. Then, if we just go to the question of duration of easement, how long an easement can be enjoyed? This is called the duration of easement. The Indian Easement Act 1882 speaks of duration of easement. The easement can be for a couple of period or a limited interest, or it may be a permanent in nature also. It all depends the individual persons. It can be as per the different periodical interruption also. It can be exercised at a particular place only, or it can be exercised on a particular point only, or it can be exercised for a particular purpose only, or it can be exercised on the existence of a prior condition only. So it may be exercised on a different particular place, or it may be exercised on a particular time, or it may be exercised on a particular purpose, or it may be exercised of a particular condition that such a right will be commenced and becomes void when the purpose will cease to effect. So now we have to go to an important distinction between easement. What are all the types of easement? This is where we are supposed to be a little bit careful, because like an anomalous mortgage, it may be a combination of some of the rights of easement clubbed together as a bundle. There are the kinds of easement that authorize the dominant owner to commit certain acts. For example, a right of drawing a water. Unless you do it positively, the easement is not acted upon. So there are some kinds of easement that authorizes the dominant owner to commit certain acts, positive acts. Right, best example is a right of drawing water from the spring, or right of walking over the pathway, etc. This is called a positive easement. There is a negative easement. Negative easement is that which restricts or limits the right granted to the servient owner over the property which belongs to. For example, a servient owner cannot block the right of light and air, etc. So when it is enjoyed by the dominant owner, it is a positive right. When it comes to the negative covenant of not to block the right, it is called a negative easement. Then we will go to the next important types of easement: continuous and discontinuous easement. So an easement can be enjoyed by a person continuously and without any obstruction, like right to access to light and air. You cannot say you have got a right of air only between January and March. Come first week of April, I'll close the window. That cannot be the case. There are certain rights which can be enjoyed perennially throughout the year or permanently. This is called a continuous easement. There are easement which can be enjoyed only interruptedly or only for a particular act is conducted. For example, drawing water. For example, in summer, if my well goes dry or the stream goes dry without water, I cannot say I got a right of drawing water when there is no water in the particular stream or well. So this is called a discontinuous easement. Discontinuous easement is the one which comes into existence only when a fresh act is conducted for exercising those rights. Example, drawing of water and at times right of pathway also. And next important type is apparent and non-apparent easement. See, apparent easement exists by virtue of existence of visible external signs, SAGNS. An apparent easement exists by virtue of existence of a visible external signs. For getting that right exercise, for example, a right to dam up a particular water course is a apparent right. Unless you put up a dam or a tank, that right is not exercised. It is called an apparent right. Non-apparent right of easement is that arises even when the signs above it are not visibly seen and they are absent. For example, restriction as to height of a building and right to get lateral support of a building. This comes when multi-story buildings come into question. Such rights cannot be seen by a visible signs. They are called a non-apparent easement. Then we will go to very important part of the story is easement by necessity. This is quite contra from easement by prescription. For example, the most important easement necessity is a right of pathway. Section 13 of the easement tax is very important to speak of this easement. It gives nearly 13A, 13B, 13C, 13D, 13E, 13F are the different provisions of the easement act that speaks of different types of easement. In section 13, only 3 subsections deal with easement of necessity. I'll just deal with it. Before that, I want to go for one important case law that is in AR 1966 Madras, page 584. AR 1966 Madras 584, Mariai Ammal versus Arunachala. Mariai Ammal versus Arunachala, where the Madras High Court has held that the most ordinary instance of a right of necessity arises when a man is unable to obtain access to or unable to derive any benefit from his own land without a right of way over another man's land. For example, I have a property called A, but I am not able to enter my property A unless I am able to enter the property of A, my property, through the property of my neighbor. This is called easement of necessity. For example, my property A is a vacant site. In the northern side, there is a building fully encircled by a compound wall. In the eastern side, there is a building encircled by a compound wall. In the western side also, there is a building encircled by a compound wall. Only in the southern side, there is a vacant site. So I cannot enter into my property unless I have a right of passage over the southern side land. But the southern side land belongs to somebody else. So I have been using the land for a long time. So this is what is called easement by necessity. I should have an absolute necessity without which I can have no access to my right of pathway. This is called easement of necessity. Please go through AR 1966 Madras, page 584. If you have the book of law of easement, section 13 has got, I said, A to F. Section 13A, section 13C, and section 13E. These 3 subsections deal with easement of necessity that is given in this section itself. If you go to section 13, for your benefit, I'll just read one para of section 13. Section 13 is very clear. Last penultimate paragraph is the easement mentioned in this section, clauses A, C, and E are the easement of necessity. So section 13, A, C, and E are dealing with easement of necessity. Then we have got something called customary easement. Please understand, customary easement is something very unique, which is neither an easement by prescription, nor an easement by grant, nor an easement by necessity. It is a separate right. Section 18 of the Easement Act speaks of customary easement. Customary easement vests in the dominant tenement, not in the particular person or a group of persons, unless they are rightfully in possession of the dominant tenement in question. The customary easement vests in the dominant tenement, not in a person. A customary right is claimed by a person or group of persons, but your customary easement is vested with the property. So, from a very nature of a thing, I can define a customary right is the one which results from a custom. Hence, the custom has to be pleaded and provided in the manner known to the Indian Evidence Act to claim customary precedent, customary easement. I'll go to a judgment of the Madras High Court to give a better appreciation of what is called customary easement. AR 1965 Madras, page 379. AR 1965 Madras, page 379. P. Karupanambalam versus SVK Karupanambalam. P. Karupanambalam versus SVK Karupanambalam. AR 1965 Madras, page 379. The Madras High Court has held easements are private rights belonging to particular persons, while customary rights are public rights annexed to the place in general. Please understand, easement is a private right belonging to a particular person, general easement, but customary right or public rights annexed to the place in general. So, if a person cannot acquire an easement right unless there was use of the same for 20 years, can he claim customary right is the question. A person is not in a position to acquire an easement right because 20 years is not over and another 2 more years is not over. In such a case, whether he can say that I have got a customary right of easement, the Madras High Court said no. This is what is there in AR 1965 Madras 379 P. Karupanambalam versus SVK Karupanambalam, because a customary easement based on a customary right is a public right annexed to the place concerned, whereas easement by prescription is a private right belonging to a particular person. Then we will go to very important right of easement in villages. Right to cart track, வண்டி பாதைன்னு சொல்லுவோம் தமிழ்ல, வண்டி பாதை, or in case of நடைபாதை, மாமூல் பாதை. This is what is a common easement right in village. So there is a judgment of Madras High Court in year 2002. AR 2002 Madras 443 equivalent to 2002 volume 2 MLJ 659. AR 2002 Madras page 443 equivalent to 2002 2 MLJ page 659. Ponnayan alias Ponnuchami versus Karupakkal. Ponnayan alias Ponnusamy versus Karupakkal. This is a judgment, a landmark judgment on what is called a cart track. It is a customary right. We have got one more easement called quasi easement. Section 13 speaks of a quasi easement also. What is called a quasi easement? There is one judgment in AR 1960 Madras 124. AR 1960 Madras 124 Ramasamy versus Munusamy. What is called a quasi easement? Apparent and continuous easement which are necessary for the enjoyment of the dominant tenement, in which it was enjoyed at the time when it was taken away from the servient tenement or the quasi tenement. அதாவது ஒரு காலத்துல ஒரு ரைட் ஓனருடைய ரைட்டா சர்வியன் டெனமெண்டா இருந்தது. ஒரு தனிப்பட்ட காரணத்தின் காரணமாக அந்த ப்ராப்பர்ட்டி பிரிஞ்சு டாமினன்ட் டெனமெண்ட் தனியா சர்வியன் டெனமெண்டா பிரியும் பொழுது டாமினன்ட் டெனமெண்ட் மேல கிரியேட் ஆகிற ரைட்டுக்கு தான் குவாசி ஈஸ்மெண்ட். ஒரே ப்ராப்பர்ட்டி பிரியவே இல்லை, கண்டினியூஸ் லேண்டா இருக்கு, அதுல ஒரு ரைட் ஆஃப் பேசேஜ் இருக்கு. அந்த ப்ராப்பர்ட்டியை ஃபார் சம் ரீசன் ரெண்டா பிரிக்கிறோம், பார்ட்டிஷன்லையோ இல்லை சேல் பண்ணும் போதோ. அப்படி பிரிக்கும் பொழுது அந்த ரைட் ஓவர் தி பர்டிகுலர் பேசேஜ் இஸ் கிவன் டு தி டாமினன்ட், அது வந்து டாமினன்ட் ஹெரிடேஜுக்கு பாஸ் ஆகும். Such easement is called quasi easement. Though it was originally in the dominant heritage, it is severed from the dominant heritage. Servient heritage adun thaniya piriyudhu appadina, the right over the dominant heritage tenement is called a quasi easement. This is given in much elucidation in Ramasamy versus Munusamy, reported in AR 1960 Madras page 124. Then we will come to the main subject of this session. We have got only half an hour more. What is called easement by prescription. I have spent more time, nearly 40 minutes, on this general introduction because without appreciating and without understanding the basic concept of easement And the types of easement called customary easement and easement by last grant and easement by grant and easement of necessity, we cannot appreciate the ingredient of easement by prescription. 4 sections are important for the purpose of better appreciation of easement by prescription. Mainly section 35, section 15. Section 15 is the main enabling provision for the purpose of defining what is called easement by prescription. Other sections are section 28, section 33 and section 35. They are to be read together conjointly in the matter of better appreciation of prescriptive right with regard to flow of right and air and other important easement. Section 15 is the important section that speaks of acquisition by prescription. For your better appreciation, let me just read verbatim what section 15 speaks of. Acquisition by prescription, where the access and use of light or air and for any building have been peaceably enjoyed as an easement without interruption for 20 years. This is what is the basic ingredient of easement by prescription. ஒரு குறிப்பிட்ட வசதி உரிமை லைக் வெளிச்சத்துக்கும் காற்றுக்குமான உரிமை அல்லது ஒரு கட்டடத்திற்கு செல்வதற்கான இடத்துக்கான உரிமை அமைதியாக எந்த ஒரு தடையும் தடங்களும் இடையூறும் இன்றி 20 வருடங்களுக்கு மேலாக ஒருவனால் அனுபவிக்கப்பட்டு வந்தால் that is called an easement by necessity, I mean prescription. So ஒரு வசதி உரிமை அமைதியாக 20 வருடங்களுக்கு மேலாக ஒரு வசதி உரிமையாக அனுபவிக்கப்பட்டு வந்திருந்தால் on the expiry of the 20th year it becomes a prescriptive easement. நீங்க அட்வர்ஸ் பொசிஷனையும் இதையும் அப்படியே parallel-ஆ நீங்க அப்ரிஷியேட் பண்ணலாம். அட்வர்ஸ் பொசிஷன்ல என்ன ஆகும்னு கேட்டீங்கன்னா 12 வருஷம் முடிஞ்ச உடனே டைட்டில் பாஸ் ஆயிடும். A person in possession of the property to the exclusion of the real owner for more than 12 years gets title. That is called adverse possession. Whereas in case of easement by prescription, on the expiry of the 20th year, he prescribes the easementary right alone. But there is no conveyance or transfer of title from the servient owner to the dominant owner. This is very important. இப்போ இந்த right of prescription is not only confined to light and air. அடுத்த ப்ரொவிஷன் பார்த்தீங்கன்னா and where support from one person's land or things affixed thereto. So இங்க வந்து right of support வருது. Then it has been peaceably received by another person's land subject to artificial pressure or things affixed thereto and it is enjoyed for 20 years. This is easement by prescription. So first parallel அவங்க சொல்றது ஒரு இடத்துல இருந்தோ ஒரு கட்டடத்துக்கோ வெளிச்சமும் காற்றும் ஒரு வசதி உரிமையாக 20 years and above எடுபச்சா அது பிரிஸ்கிரிப்ஷன். அதே மாதிரி அடுத்த கிளாஸ்ல ஒரு பில்டிங்க்கு அடுத்த இடத்துல இருந்து ஒரு சப்போர்ட்டோ ஒரு அஃபிக்ஷன் சப்போர்ட்டோ கிடைச்சதுன்னா அந்த உரிமையும் 20 years முடியும் பொழுது இட் பிகம்ஸ் எ பிரிஸ்கிரிப்டிவ் ஈஸ்மென்ட். அடுத்தது ரைட் ஆஃப் வே, வேர் எ ரைட் ஆஃப் வே or any other easement has been peaceably and openly enjoyed by any person claiming title thereto as an easement and as of right without interruption 20 years. So first சொன்னது light and air, ரெண்டாவது lateral support from another building or another land, third வந்து right of passage. Then அடுத்தது the act section 15 says the right to such access or use of light or use of support and other easement shall be absolute. So this is where the easement is different from adverse possession. நீங்க section 28 of the easement act பாத்தீங்கன்னா, I mean limitation act பாத்தீங்கன்னா, on the expiry of the 12th year in case of adverse possession or as against the government on the expiry of 30th year, the person in possession of the property to the adverse ownership of the original owner or real owner or true owner loses his right, a title, and the title will pass on to the claimant who has got adverse possession. ஆனால் இங்கே ஈஸ்மெண்ட்ல அப்படி இல்லை. On the expiry of the 20th year, what happens that the right of easement of light, air, support and pathway which have been enjoyed by him for more than 20 years becomes an absolute right on the expiry of 20th year. This is the important distinction. 20 வருஷம் முடிஞ்ச உடனே அந்த ரைட் அப்சல்யூட் ரைட் ஆகுது. அதுக்கப்புறம் என்ன சார் பண்ணலாம் அப்படின்னு கேட்டிங்கன்னா, ஃபார் எக்ஸாம்பிள் 20 இயர்ஸ் முடிஞ்சு போச்சு, எனக்கு ஒரு ரைட் ஆஃப் ஈஸ்மெண்ட் கிடைச்சது, திடீர்னு அந்த ஒரு பிரச்சனை வருது, நான் என்ன பண்ணலாம் அப்படின்னா, if at all I want to file a suit for the purpose of a declaratory decree or in case of injunction against disturbance or in case of compensation against disturbance, section 35 அதெல்லாம் வரும். What is the limitation period? This is where most of the aspirants in examination commit a mistake. They immediately say, Pat came the reply, 20 years. I'm sorry, that is not the correct answer, because next paragraph is very important. It reads, each of the set periods of 20 years. அதாவது ரைட்டுக்கும் லைட்டுக்கும் அக்சஸுக்கும் lateral சப்போர்ட்டுக்கும் உள்ள ஒவ்வொரு பீரியட் ஆஃப் 20 இயர்ஸும் each of the set periods of 20 years shall be taken to be a period. Please closely follow typical British parliamentary wisdom. Each of these set periods of 20 years shall be taken to be a period ending within 2 years. So அந்த 20 வருட பீரியட் அப்படிங்கிறது இன்னொரு 2 வருஷத்தோட முடியணும். அப்ப 22 வருஷம். அந்த 2 வருஷம் எப்ப முடியணும்? Ending within 2 years next before the institution of the suit or immediately before the institution of suit. For example, now we are in 2021. 2000 I got a right of access to another man's land. 1/1/2000 வச்சுப்போம். 31/12/2020 I have prescribed the right to the right of passage. But I cannot file the suit on 1/1/2021 because according to the section, அதுக்கடுத்த 2 வருஷம் முடிஞ்ச பிறகுதான் I can see that right is declared. So, if at all acquire right of prescription of a right of passage on 1/1/2020, 1/1/2000, I get a right of prescription on 31/12/2019, but my right to file a suit comes only on 1/1/2022. So, the actual period of limitation only for a right of prescriptive easement. This 20 plus 2 year is not an ingredient for any other easement. Easement by last grant to go, easement by grant to go, easement by necessity go, customer easement to go in the 20 plus 2 years வராது. Please understand, if we come to know of a plaint or written statement which speaks of acquisition of easement by prescription only, section 15 applies. When a right of easement is prescribed by 20 years of enjoyment, he will get the right absolute, but his right to get is enforced fructifies only on the expiry of the 22nd year. இதுக்கு என்ன மீனிங் கேட்டீங்கன்னா, அந்த 20 வருஷத்துக்குள்ள அந்த ரைட் டிஸ்டர்ப் ஆனாலும் he cannot prescribe the right. But even after the prescription of right of easement, if the original owner of the property disturbs his enjoyment within the 2 years period, the suit is not maintainable. So please understand that 20 plus 2 year, இது ஒரு கைண்ட் ஆஃப் வனவாசம் மாதிரி, 14 இயர்ஸ் மாதிரி, 22 இயர்ஸ். அந்த 2 இயர்ஸ் எதுக்காக வச்சாங்கிறத நான் எந்த புக்லையும் என்னால் கண்டுபிடிக்க முடியல. எவ்ரி ஆத்தர் gives a different interpretation. I don't know why. I am not able to lay my hands on the objectives of section 15 of the Eastman of the year 1882, probably British Parliamentல என்ன பண்ணிருப்பாங்க. So I'm not able to understand the logic behind having one more 2 years of period to claim the right over and above 20 years. I'm sorry, absolutely no reason is given. But That is the law of the land. So unless you exercise the right of 20 years continuously, peaceably, as an easement, as a right on the other man's land, and thereafter you see that your right is protected, not disturbed by the real owner for 2 more years, you can file a suit for a declaration degree or any other right. This is what section 15 is all about. Now, we have to see what next is there in case of law of easement. As I said already, section 13 speaks of easement of necessity. Section 18 speaks of easement of customary easement. Section 15 speaks of easement by prescription. Now, we will have to go the next important provision, what is called a disturbance to the easement in a case of a cause of action invented for the purpose of this suit. So before that, for the better appreciation of the period of 20 plus 2 years that is occurring in section 15, a judgment of the Allahabad High Court, I find it very comprehensive, very illustrative, and it is a compendium on the law of limitation vis-a-vis the right of easement by prescription. AR 1980, Allahabad, page 389. AR 1980, Allahabad, page 389. Syed Manzoor Hussain. Syed Manzoor Hussain versus Hakim Ahmad. In the said case, the Allahabad High Court has given the formula to reckon the period of 20 plus 2 years in an easily understandable way. Please have some more time, leisurely and academically go through the judgment for better appreciation of section 15 in the light of section 25 of the Eastment Act. I repeat once again, the prescription of continuous, peaceable, uninterrupted as a matter of easement right enjoyment of an easement is available only under section 15, that is governing an easement by prescription. Section 15 has got no application to any other easement, and the relevant provision of limitation act is section 25. Section 25 speaks 20 years plus 2 years, and in addition to section 15. Okay, then we have to see what kind of pleading is required in such a suit. There is judgment of Madras High Court in 1972 2 MLJ, page 435. It is there in my mind. It is 1972 2 MLJ, page 435. PV Krishna Iyer versus Perumal Nadar. The court says that if a plaintiff put forward specifically the claim of title and having failed to claim title, he cannot fall back on the easement right. This is the requirement of pleading. Then why we are very careful in a suit for easement is because ordinarily a court can find a case and decree the suit on the basis of the pleadings of parties. We are not bound by strict rule of pleadings normally. But in extraordinary case like adverse possession and easement, it is all the more necessary that the pleading should be precise and specific, because we are taking away the right of one person and conferring to another person. So we should be very careful in pleading easement. Then certain rights cannot be acquired by prescription. That is there also in the section 17 of the Eastment Act. Section 17 gives 4 exceptions or incidents where an easement cannot be acquired by prescription. First one, a right which would tend to the total destruction of the right. ஒருவேளை அந்த வசதி உரிமை கேட்கப்படும் பொழுது அந்த என்டையர் ப்ராப்பர்ட்டியை அழிஞ்சு ஒன்றும் இல்லாமல் போயிடும் அப்படின்னா யூ கேனாட் ஆஸ்க் ஃபார் எ பிரிஸ்கிரிப்டிவ் ஈஸ்மெண்ட். ரெண்டாவது, ஒரு ஓப்பன் ஸ்பேஸ் ஆஃப் கிரவுண்டுக்குள்ள ஈஸ்மெண்ட் ஆஃப் ரைட் அண்ட் light and air cannot be granted, and ஒரு சர்ஃபேஸ் வாட்டர்ல உள்ள ஒரு ஸ்ட்ரீம்ல ஃப்ளோ ஆகாத ஸ்டாக்னன்ட் வாட்டருக்கும் we cannot prescribe title, and ஒரு டிஃபைன்டு சேனல்ல போகாத அண்டர்கிரவுண்ட் வாட்டர், இந்த நாலுக்குமே பிரிஸ்கிரிப்ஷன் ரைட் வராது. ஐ ரிப்பீட், a right which would tend to the total destruction of the subject of the right cannot be prescribed. A right to free passage of light or air to an open space cannot be granted, prescribed. A right to surface water not flowing from a stream and not permanently collected in a tank, etc., cannot be claimed. And a right to underground water not passing in a defined channel cannot be claimed according to section 17. Then we'll have to go to other provisions of the Easement Act, which are in the nature of speaking about the disturbance to easement. Section 32 அதிலிருந்து ஆரம்பிச்சு 35 வரைக்கும் we are going to see about the disturbance of easement and what could be done. 31, 32, 33 they speaks of how your easement can be disturbed. But நமக்கு வேண்டிய முக்கியமான செக்ஷன் வந்து செக்ஷன் 35. செக்ஷன் 35ல உள்ள ரிலீஃப் என்னன்னு கேட்டிங்கன்னா, there are two kinds of cause of action contemplated by section 35. ஒன்று வந்து actual disturbance to easement, ரெண்டாவது intended or anticipated or proposed disturbance. So section 35A speaks of actual disturbance. The right is infringed, the right of easement is disturbed, it is damaged. Section 35B speaks of an anticipated or proposed or expected or intended disturbance to injunction. அப்படி வரும்பொழுது நம்ம என்ன மாதிரி ஒரு ரெமெடி கேட்கலாம் அப்படின்னா, செக்ஷன் 37 speaks of the remedy in case of application of section 35. So they can have two kind of relief. ஒன்று வந்து நம்ம காம்பன்சேஷன் கேட்கலாம், இல்லைன்னா இன்ஜெக்ஷன் கேட்கலாம். Expected, proposed, anticipated, intended damage or disturbance, we can go for an injunction. Actual commission of disturbance, in case if you want to stop it, you can go for injunction, or it is beyond stoppage, you can go for compensation. This is the disturbance. Then when we go to extinction of easement, randomly ஒரு 11 section இருக்கு easement act, section 37 to 38. They deal with a different occasion in which extinction can be granted. As Ma'am Adilashmi has suggested, on the part of the story, we will deal with on some other occasion when time permits. Then section 51 deals with revival of easement. ஏற்கனவே எக்ஸ்டிங்ஷன் ஆன ஒரு ஈஸ்மெண்ட்டை எப்படி ரிவைவ் பண்றது அப்படிங்கிற செக்ஷன் 51 will speak. Then there is some kind of thing called suspension of an easement temporarily, what is called keeping in abeyance, that is provided under section 49 of the Eastment Act. இதெல்லாம் இப்போ we are not going to speak. Now we are on section, I told you, section 4, section 12, section 13, section 15, section 18, section 35 and section 47. 47ல ஒரே ஒரு விஷயம் மட்டும் I want to say, because this is one of the section highly misunderstood by most of us concerned. 47 of course deals with the extinguishment of an easement. அதுல நான் என்ஜாய்மெண்ட், ஒரு பர்டிகுலர் வசதி உரிமையை நாம் தொடர்ந்து அனுபவிக்கவே இல்லை என்றால் அந்த ரைட் எக்ஸ்டிங்கிஷ் ஆகுங்கிறது தான் செக்ஷன் 47 உடைய தாத்பரியம். ஃபார் எக்ஸாம்பிள், a continuous easement is extinguished when it totally ceases to exist, to be enjoyed as for an even unbroken period of 20 years. 20 வருஷமா கூட ஒரு ரைட் அனுபவிக்கல, அது டோட்டலா என்ஜாய் பண்ணலன்னா that becomes distinct. A discontinuous easement is extinguished when it is not enjoyed for a minimum period of existence. ஸோ இப்படி வரும் பொழுது அந்த மாதிரி டிஸ்கண்டினியூஸ் ஈஸ்மெண்ட்டோ அல்லது ரெஜிஸ்ட்ரேஷன் ஆக்டில் வரக்கூடிய ஒரு டாக்குமெண்ட்ல வர்ற கிராண்ட் ஒரு டிஸ்டிங்ஷன் ஈஸ்மெண்ட்டோ, it is not going to destroy the right completely. It can be revived in case of possibility under section 49 of the Eastment Act. So normally, when we go to the basic principles of Eastment Act, we are governed by this section only. Now, let me go to some very important case laws that are very much relevant for the purpose of appreciating the practical difficulty in case of persons who are aspiring for the judicial officers examination. I want to cite one judgment of Madras High Court of the year 2011 in which previous landmark case laws are discussed. Before that, let me go to one important thing called party wall. நம்ம எல்லாமே பார்த்துருப்போம் பார்ட்டி வால் அப்படிங்கிறது. பெரும்பாலும் சில ஊர்களில் பார்த்தீங்கன்னா வீடுகள்லாம் ரோ ஹவுசஸாக இருக்கும். பெரும்பாலும் அக்ரஹாரத்தில் இப்போ ரோ ஹவுசஸ் அப்பார்ட்மெண்ட்லேயும் பார்க்குறோம். அப்படி வரும்போது ஒரு மனிதனுக்கு ஒரு வீட்டுடைய ஒரு பக்க சுவர் மட்டும்தான் அவனுடைய சொந்த சுவராக இருக்கும். நார்மலி இட் இஸ் ஆன் தி லெஃப்ட் சைடு. ஸோ அந்த மாதிரி சமயத்தில் அல்லது ஒரு வீட்டுக்கு ரெண்டு வீட்டுக்கு ஒரே சுவர் காமன் வாலாக இருக்கலாம். ஒரு பெரிய வீட்டை ரெண்டாக பிரித்து அண்ணன் தம்பி கூட எடுத்துகிட்டு இருக்கலாம். அண்ணன் ஒரு போர்ஷனை விற்கலாம், அது தேர்ட் பார்ட்டி வாங்கலாம். இப்படி வரும்பொழுது திஸ் இஸ் கால்ட் ஏ காமன் வால். த காமன் வால் இஸ் கால்ட் ஏ பார்ட்டி வால். பார்ட்டி வால். பார்ட்டி வாலில் வந்து ஈஸ்மெண்ட் வராது. ஃபார் த சிம்பிள் ரீசன், party wall is owned by both parties equally. Common compound wall or common support wall or common wall is a matter of joint ownership by both parties. I already told you, when the person who claims easement asserts title in the property, it can never be an easement. So in a party wall, there is a joint ownership. Another party wall easement la varadu. This has been clearly held by the Madras High Court in 2011, 2 Law Weekly, page 450. 2011, 2 Law Weekly, page 450. Justice R.S. Ramanathan in a case between M. Paramasivam versus I. Karupaiya. M. Paramasivam versus I. Karupaiya, 2011, 2 Law Weekly, page 450. In this case, in para 6 of the judgment, Justice R.S. Ramanathan has painstakingly explained what is the law of party wall. So please go through, especially I would recommend para 8 and 9 for better appreciation of law of party wall. Please understand, in party wall there is no scope for claiming easement because party wall is owned by both the parties equally. அடுத்த judgment is of the Kerala High Court. So one of the finest judgment on the entire subject of Eastment Act. Section 4 ஆரம்பிச்சு செக்ஷன் 18 வரைக்கும் ஈஸ்மெண்ட் ஆக்டுடைய ஒவ்வொரு டைமென்ஷனையும் அக்குவேராக ஆணிவேராக பிரித்து ஆராய்ந்து எழுதப்பட்ட ஜட்ஜ்மெண்ட். That is reported in, I think it is not in Tamil Nadu Law Journal. Unfortunately, it has been reported in ACJ. I don't know how it came to ACJ. 2012 ACJ, page 1036. If you have access to Kerala Law Times, 2011 Kerala Law Times, page 605. Mathai versus Jordi Paulos. Mathai versus Jordi Paulos or Jordi. This is a case, I would say it is a classic case of an entire law of easement is condensed in nearly 5 pages. One of the recommended judgments for exam aspirant to understand the law of easement in a nutshell. Please go through this judgment. It has got 20 paragraphs. It has got both English law and Indian law condensed and encapsulated for the purpose of appreciating the academic side of the law of easement. Then, acquisition of easement right of light and air through a window of a common wall. இதுவும் ஒரு மிகப்பெரிய இன்ட்ரெஸ்டிங் சப்ஜெக்ட். ஒரு காமன் வால் இருக்கு, அந்த காமன் வால்ல ஒரு விண்டோ இருக்கு. அந்த விண்டோ வழியா a person enjoys a right of light and air அப்படின்னா அது ஈஸ்மெண்ட்ல வருமானக்கா ஒரு ஜட்ஜ்மெண்ட் ஆஃப் மெட்ராஸ் ஹை கோர்ட் ஆஃப் தி இயர் 1988. A doyen in the form of a judge called Justice V. Ratnam, he has rendered judgment in the year 1988. 1988 One Law Weekly, page 135. R. Pandian versus Nahammal and another. 1989 2 MLJ 241, R. Pandian versus Nagamal and another. Here, Section 7D of the Indian Easement of 1882 is discussed threadbare, where the Madras High Court has given what is the distinction between a right of light and air as an easement and a right to draw light and air through a common wall of a common wall. This is also of academic interest. Please go through when you have free time. Then I have one judgment regarding distinction between license and easement. This is also of academic interest because I have found this question in nearly 5 or 6 years of direct district judge examinations. So this judgment of the year 2000 by one of the finest civil judge of Madras High Court, S.S. Subramanian J, is something for a pleasant and academic, insightful reading. 2000, Volume 3, Law Weekly, 182. Year 2000, Volume 3, Law Weekly, 182. Justice S.S. Subramanian. Devendra Kumar versus Ranganathan. Devendra Kumar versus Ranganathan. 2000, Volume 3, Law Weekly, 182. It's a compendium on the law of a distinction between lease and license. Then, once again, we'll go to what is the basic definition of easement. Section 4. Section 4, how best it can be understood, is the judgment of the year 1966. 1966 or 79, Volume 79, Law Weekly, page 632. நீங்கள் ஒன்று இயர் எடுத்துங்க, ஏன்னா அப்போல்லாம் லா வீக்லி வால்யூம் தான் வந்தது. ஸோ எதர் இட் இஸ் 1966 Law Weekly or Volume 79 Law Weekly, page 632. Justice M. Nadesan. Parties வந்து A. Karupaiya Pillai versus Narayana Mudaliar. Here, the judge has painstakingly explained with minutest detail in a short and sweet and precise judgment about the scope of the definition of easement under Section 4 of the easement. Then finally, I want to rely upon one judgment of Supreme Court for the purpose of the nature of pleading in a suit on easement. Most of the time, the judgments are not in a favor of the plaintiff because the pleading is lacking material particulars. I told you, since the right of easement is the nature of taking away a right, a pleading should be precise, concise, and very specific. 1987 AAR, Supreme Court, page 1242. AAR 1987, Supreme Court, page 1242, equivalent to 1987 2 SEC 555. AAR 1987, Supreme Court 1242, equivalent to 1987 2 SEC 555. Ram Sarup Gupta versus Bishan Narayan, Inter-College. Ram Swarup Gupta versus Bishan Narayan, Inter-College. This is a case where Justice Sabyasachi Mukherjee, Chief Justice as he was, and K.N. Singh, they have deliberated very clearly about what is the scope and ambit of pleading in such a suit.